Hello, this is Matt on the Moon Lambeau channel. An SEC insider has told Fox Business that the SEC is probably going to file an appeal in the SEC v. Ripple lawsuit, and that perspective is based on his own first-hand insider information. So I'm going to share with you all the specifics that we know to this point. This is a news story just breaking within the last couple hours or so. I already, though, have perspective from several XRP community member attorneys. That would include attorney Jeremy Hogan, attorney John Deaton, attorney Bill Morgan, and attorney Fred Rispoli. So are we at risk of something disastrous happen? Is this going to harm the price of XRP and ruin the opportunity for another bull run if there is an actual appeal? Well, let's break all of that down. But before going any further, I do want to be clear, I do not have a financial background of any kind. I am not offering financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. All right, so here's the story breaking just a few hours ago. It comes from Fox Business journalist Eleanor Terrett, and she posted this on X, the following. And so this is her source. Her source is a former SEC attorney, but up until recently was actually working at the SEC, and so the perspective would absolutely be relevant. You could question any former SEC attorney who hasn't worked there in half a decade and be like, okay, well, but this is an attorney who until recently was working there. So check out this. Eleanor Terrett wrote the following. New. A former SEC lawyer who recently left the agency tells me the SEC will probably appeal Judge Torres's July 2023 ruling concerning the XRP programmatic sales in the Ripple case, partly because, quote, so this is a quote from the source, everyone over there at the SEC truly believes that the decision is wrong, that it's not good law, and should be appealed, end quote. Do they really believe that? I kind of, you can't tell for sure which things they say they believe and which things they don't, because so frequently throughout the case, and I said this so many times throughout the case, because I covered every single legal brief, every single filing, all the developments in the case for years on end, and so frequently I caught myself just thinking, there's no way these asshat pricks believe what the hell they're arguing. There's just no way. It's incomprehensible. But who knows? They're in an echo chamber. Maybe they trick themselves into believing some nonsense. I can't technically know for sure. But some of this stuff is just so ridiculously absurd. You just got to kind of wonder, right? Then she says, going to do a deeper dive into the SEC's options and what we could see as we near the October 7th appeal deadline. Right, and so we'll know soon. We'll know by the time October 7th rolls around here. I just thought I'd go ahead and share with you, where is it? Actually, you know what? This is what I want to pull up next. So the question being, then I'm going to share with you what the attorneys had to say, but the question is, can the SEC actually appeal the decision on XRP itself? Well, the attorneys actually speak on that. I'll just tell you up front right now, the answer is no, but not only that, the SEC already publicly stated in a filing to Judge Torres last year that they will not be seeking appeal on the legal status of XRP as its non-security status. So here's a post that I wrote on X, August 18th, 2023. This is over a year ago now. And here, I'll make this full screen, and I boxed this and read myself on the day that this broke. I wrote, the SEC is now blatantly stating they are not challenging Judge Torres' decision that XRP is not a security. Anyone that says the Judge Rakoff comment is a threat is mistaken, as even the SEC doesn't believe that. And I won't get into the Judge Rakoff stuff. That's another hot topic at the time in August of last year, but for the purposes of this video, I don't want to get into it. But the relevant portion, again, of the box. This is what the SEC wrote. Quote, and the SEC does not seek appellate review of any holding relating to the fact that the underlying assets here are nothing but computer code with no inherent value. And so there you go. Even the SEC saying, yeah, we're not going to appeal, and they actually can't anyway, because I don't want to get too into the weeds here, but as Jeremy Hogan first pointed out over a year ago, that was just dicta. It's not something that was technically to be ruled on in the case, but it's dicta. You actually can't appeal that anyway. But even if they could, the SEC is saying here, we're not going to do that. It's just computer code. What are you talking about? Right? And so what can they appeal on? Well, they can appeal in programmatic sales. So we're going to talk about that as well. Actually, before I forget, let me say this too, because you might be wondering, on the issue of price, is this something that's going to destroy XRP's opportunity for a bull run? I say no. I feel fairly strongly that the typical XRP holder understands that even if there's an appeal, this isn't going to impact the long-term viability or even the legal status of XRP itself. That is true unequivocally. What I just stated there is fact. That is not my opinion. I think most people know that now. I don't think everyone knows that now. So if there is an appeal, it won't surprise me if to some degree XRP, even if it's just a little bit, it might, I don't know for sure, but it might take a bit of a hit. It's hard to believe that it would be disastrous, though. It's really hard, because I really think most people get this. And some of the evidence that I cite to support this position is the fact that XRP, before the bull run really got hot, in July of last year, XRP got legal clarity, the price doubled in 4 hours, right? And it's like lots of exuberance for good reason. I was very excited too. It was one of the best days ever. Well, then, over a year later, you get the conclusion of the SEC v. Ripple case. And as I said going into it, it shouldn't matter for the price of XRP, because we already know XRP is not a security. That is the legal status of it. Everything's good. And I acknowledge there's a possibility the price could pop. It just wouldn't be rational. And the price, it went up a little bit. I don't know to what degree you want to call it a pop. It went up like 15-20% in short order. But see, that's what I'm saying. It's like think about it. That didn't matter to almost anyone. And this is in more of a bull environment. If anything, you'd think that there'd be more excitement if people actually thought that it mattered. So it mattered, the legal clarity mattered, but then this, when the Ripple case ended and it really just mattered to Ripple, yeah, almost nobody thought it mattered, which makes sense. And so here, this is the reason I'm saying this, if there's an appeal, I think that the typical person already knows it's not going to matter. So some people might freak out, especially if they're uninformed and emotional, but I still don't think that it's going to result in XRP not being capable of participating in the bull run. That just doesn't make any damn sense. That really just doesn't make a damn bit of sense to me. So there was this post. So let's break some of this down. There was this post from crypto influencer Wendy O. She reposted what I just shared with you from Fox Business journalist Eleanor Terrett, and Wendy wrote the following. If the SEC appeals Judge Torres' ruling that XRP is a security on the secondary market, the crypto industry future could seriously be effed. And so that's not even actually what's being, that's not even what was ruled on. Programmatic sales are what was ruled on, and that's different than secondary market sales. And this is actually broken down in detail by XRP community member and attorney Fred Rispoli. And so Fred responded to Wendy and offered some clarity on this. He wrote, Wendy, it's nuanced, but the SEC lost on programmatic sales, not secondary sales. They are similar in concepts, but are not identical. Secondary sales were explicitly excluded from the judge's analysis. Page 23, blah, 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 on the 7/13/23 order, if you want to read it. And so somebody named Coach V responded to that and said, what's the difference between programmatic sales and secondary sales? Excellent question. I'm glad he asked that. And Attorney Rispoli did respond. He says, programmatic sales were defined by the parties as Ripple selling XRP on exchanges or using trading algorithms. So Ripple selling to Gary on Coinbase was a programmatic sale. Gary selling to Jay on Coinbase would be a secondary sale. And so basically anything that's programmatic, it's Ripple. And the way that I understand, because they weren't selling to end users, mind you, so that's not quite precise, unless I'm mistaken, in which case somebody, fact check me in the comment section below, but I'm almost 100% sure that what Ripple was doing through programmatic sales was selling. It was selling just blindly or to the exchange itself. So like to be clear, like they didn't know who they were actually functionally selling to. That's the only point that I'm trying to make. And maybe that's what Fred Rispoli means. There's a chance that I was just misinterpreting what he said there anyway. But that's true. So there's programmatic sales and then there's secondary sales. Now, Ripple named those types of transactions programmatic sales. That's the reason that term was used throughout the SEC v. Ripple lawsuit. So Ripple came up with that, and then the SEC continued to use it, and then as a result, Judge Torres used it. So basically, it was those types of sales by Ripple, those were called programmatic sales. But then secondary sales, so then once it's on the market, so it's like, say you get your XRP and you bought it on Coinbase, even if it was directly from Coinbase, let's say, you don't know, it was a blind transaction, you don't know who it was from, right? And so And so that's also, if you go to the Howey test too, that's one of the reasons that Judge Torres is like, yeah, if you're buying blind, you can't be counting on the efforts of Ripple if you don't even know that you're buying it from them. Duh. Which is another reason why I'm like, how can the SEC possibly believe that these programmatic sales are somehow breaking the law? Like, and satisfying the, like, as far as the Howey test is concerned. It just doesn't make any damn sense. So then the secondary sales themselves, which is not something that was actually being ruled on here, that wouldn't be impacted by this. So that would mean you and I blindly buying XRP from and selling it to one another on Coinbase or Binance or pick your exchange, that's not impacted here. It would just be Ripple sales. So even if there was an appeal, and even if Judge Torres was found to be wrong, and even if the SEC got their way and then programmatic sales were found to be illegal, which isn't going to happen, and I'll explain why further in a minute. John Deaton does, actually. Even if that happened, that wouldn't impact transactions that are taking place that are known as secondary transactions. So from you and I on exchange. These are specific to Ripple. So this is another reason it doesn't make sense to freak out about this. And so for the people that are informed, they're not going to be panic selling their XRP if there's an appeal. That's all I'm saying. And there really might be. I'm not going to make a prediction because the SEC is completely absurd. It just seems pointless to me. I don't think it's in their interest, but they do stuff that's not in their best interest sometimes. So why am I going to bother making a prediction? So anyway, I appreciate Rispoli, kind of straightening that out there. And then there's also this from attorney Jeremy Hogan. He responded to Eleanor Tart and wrote, "Of course they think the opinion is wrong. They were on the losing side. What the SEC should be thinking of right now is whether an appeal furthers its mandate of investor protection and capital formation. Why isn't that top of mind? More evidence the SEC has lost the plot." You're correct, Attorney Hogan, 100%. And I will answer your question. Why isn't that top of mind? Well, it's easy. It's because they're a bunch of asshat pricks. That's it. They're just a bunch of asshat pricks. Hell spawns, basically. Winged creatures from the depths below. That's them. Then we have this from Attorney John Deaton. And so he broke down further why, and you're going to love this, even if there's an appeal, and even if it's like, quote unquote, successful, it's not really successful. Because if the appeal finds that Judge Torres erred in her ruling, the decision still gets thrown back to her, and she has other maneuvers that she can engage in. So check this out. It's from Attorney John Deaton. As someone who knows the Ripple case very well, considering I was an active litigant for over 2.5 years, and considering Judge Torres cited my amicus brief and the 3,800 XRP holder affidavits I submitted, as well as my efforts as amicus counsel in the library case, see footnote 16, let me comment. In the Ripple case, Judge Torres did not apply all 3 factors of the Howey test. And then I'll pause and note in parentheses, he wrote the following, because you may have heard that the Howey test is a 3-factor test. You may have heard it's a 4-factor test. And so he explains in parentheses, some people describe the Howey test as a 4-factor test because the 3rd factor has 2 prongs. And then he says, I don't believe an appellate court will rule Judge Torres was in error in applying the 3rd prong. Judge Torres made her ruling very fact-specific. The SEC did not rely on any expert testimony related to XRP holders. It was excluded anyway, but the judge did rely, however, on the XRP holder affidavits I submitted. An appellate court could say, just as Judge Torres acknowledged, there could be a scenario where secondary sales could qualify as investment contracts because the facts meet all the Howey factors. And so I'll pause to note that that's certainly true, and I've discussed this in the fact. So secondary market transactions, so it could be like a transaction from me to you, that by default isn't some sort of illegal securities transaction, but it's possible to have a secondary transaction like that would satisfy Howey. If you can show that there is a common enterprise between, so we're talking between you and I, and there's something there, and then all the other factors of the Howey test, that could happen. So you could have some secondary transactions that satisfy Howey, meaning, yeah, those are illegal securities transactions, but they aren't by default that. Secondary transactions are not by default illegal securities transactions. And in fact, the vast majority, and this is provably so, it's just speculators who don't even know each other, buying and selling XRP back and forth on exchanges. That's the vast majority. Of course, those don't satisfy Howey. Just saying, there could be situations where there's more behind the transactions than you might see on the surface, and if you dig into that, you're like, oh wow, so you're promising the XRP goes higher based on these efforts, so on and so forth. Okay, then you might be able to have a case. But that also doesn't make XRP in and of itself a security. Anyway, and then attorney Deaton continues. But in the Ripple XRP case, the facts presented just don't justify it. Thus, the case gets affirmed on appeal, but it doesn't prevent the SEC from arguing secondary sales constitute investment contracts in other cases. Finally, Judge Torres ruled secondary sales on exchanges did not satisfy the third prong of Howey, and since all Howey factors must be satisfied, there was no need for her to apply the second prong, common enterprise. And so, folks, he's just saying there's 3 prongs of the Howey test. Judge Torres ruled on just one of them because that's all she needed to do. In order for something to satisfy the Howey test, meaning it's an illegal security transaction anyway, all you have to, in order for that to happen, you have to satisfy all the prongs of the Howey test. So as soon as you find that one of them isn't satisfied, you don't need to talk about the other ones if you're Judge Torres, and she didn't. She said, hey, here's one that's not satisfied. Didn't even bother to talk about the rest. It wasn't necessary. But you see, there's strategy behind that. So check this out. Attorney Deaton then says, let me just reread that so it flows better. Finally, Judge Torres ruled secondary sales on exchanges did not satisfy the third prong of Howey, and since all Howey factors must be satisfied, there was no need for her to apply the second prong, which is common enterprise. The common enterprise factor was, in my opinion, the weakest part of the SEC's case against Ripple. Thus, even if the Second Circuit ruled Judge Torres erred applying the third prong, the SEC doesn't win the case. The case would go back to Judge Torres for her to apply the common enterprise prong, and she would likely rule the SEC didn't establish a common enterprise. If that happened, the SEC would lose again and then have to appeal all over. It makes no sense to appeal this ruling. If Judge Torres did rule against Ripple, Ripple could then appeal. It makes no sense and would be a total waste of taxpayer money to appeal this decision, which is why someone like Gary Gensler might just appeal. Facepalm emoji. Exactly, he really might. And it's probably not going to go well, but that could happen, absolutely. And so the cool thing here, to be clear, is even if there's an appeal and the court's like, oh yeah, you made a mistake, Judge Torres, then it goes back to her, and all she's got to do is rule on one of the other prongs of the Howey test and be like, yeah, it doesn't satisfy. There you go. And then it's your move again, SEC. Now how you going to act? See, they're not in a good position. And again, all of this does not impact XRP itself, and we're not even talking about secondary market transactions. We're talking just about Ripple's transactions. This isn't going to hurt us. Then there was this post from Attorney Bill Morgan. He reposted me sharing this news from Eleanor Tarrant, and Attorney Morgan wrote the following. I stand by my 60% chance of appeal on the programmatic sales part of the decision. So he thinks more likely than not the SEC is going to appeal, and wouldn't be surprised. He also wrote, don't think the SEC will appeal on penalty/disgorgement decision. Yeah, and so they already spoke publicly about that, and they seem pretty... they played it off as though it was a win, even though they were asking for $2 billion. They only got $125 million. Fine, whatever. So that part's probably correct. I'm not going to personally predict, again, like I said, if they're likely to appeal or not. We're just going to find out together. Either way, this isn't going to hurt us XRP holders, and so that's the latest. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.